Hello and welcome to Timmy Mac Law with me, Mr. McClellan. For this video, we are going to focus on the offences of wounding and grievous bodily harm under Section 20 of the Offences Against the Person Act 1861. And it's important to note the section number here because wounding and grievous bodily harm for this video comes under Section 20 and not Section 18, because wounding and GBH can also be Section 18 offences. I'm not going to spend too much time talking about the difference between Section 18 and Section 20, wounding and grievous bodily harm, except to say that it comes down to a matter of the difference in the mens rea and the level of fault which can be attributed to the defendant. In short, Section 18 wounding and GBH is the more serious kind of wounding and GBH in comparison to Section 20. So for this video, we are going to focus on the less serious side of wounding and grievous bodily harm, because they fall under, for this video, Section 20 of the OAPA. They are triable either way offences. They can be tried and heard in the magistrate and indeed the Crown Court, and they carry a maximum sentence of 5 years, which is rather interesting because Section 20, wounding and grievous bodily harm, carrying a maximum sentence of 5 years, is also the same as assault occasioning actual bodily harm, that less serious offence also carrying the same maximum sentence of 5 years. And that really is down to an oddity, or indeed a quirk, if you like, of the Offences Against the Person Act 1861, that rather old and some would say outdated statute. So just be aware that it is a little bit illogical to have the offence of assault occasioning actual bodily harm have the same maximum sentence as the more serious offences of Section 20 wounding and grievous bodily harm. So just bear with that. We're not going to dwell on it for the purposes of this particular video, but just take note of it, in other words. Now, in terms of the definition of wounding and grievous bodily harm, this definition is taken directly from the statute of the Offence Against the Person Act 1861, so it is a little bit wordy, if you like. Here it is: wounding and grievous bodily harm. Whosoever shall unlawfully and maliciously wound or inflict any grievous bodily harm upon any other person, either with or without a weapon or instrument, shall be guilty. I'll say that definition again and pay close attention in particular to the first two lines, because you will see certain words or phrases which are underlined, which we are going to analyse a little bit later on. So here we go. Wounding and grievous bodily harm can be defined as whosoever shall unlawfully and maliciously wound or inflict any grievous bodily harm upon any other person, either with or without a weapon or instrument, shall be guilty. I wouldn't necessarily worry about remembering all of that definition word for word. You really just need to grasp what a wounding or indeed a grievous bodily harm actually is, as clarified through all the cases that we are going to look at and indeed the associated principles. So don't worry too much about learning this definition. The important thing when it comes to your exam answers is that you know what a wound and a GBH actually looks like. So without further ado, let's take the first key word from that definition, and it's the word unlawfully, which means that the act must be against the law. And of course we're focusing on the actus reus to begin with, as you should do for all your offence analysis, and indeed the act must be against the law, which really speaks of certain situations where indeed it may be justified to act in a way which causes a wound or GBH because it is legally justifiable. So for example, you may have the police executing a lawful arrest, you may have issues of self-defence on behalf of the defendant, you may also have a consensual situation whereby in some respects the victim has consented to the GBH, or at least some harm being committed against them. And if that is the case in relation to those three very simplistic situations, then the act can be said to be lawful and not unlawful, not against the law. Okay, so sometimes a GBH can be lawfully committed against someone, as strange as that may seem, but hopefully you can understand and appreciate how that can happen with those three really simple examples to do with consent, self-defence, and indeed the police executing a lawful arrest. Moving on, what does a wound actually mean? Now, you'll all have an image in your head, perhaps, of what a wound actually is, but when it comes to the law, the wound can be defined as a break in the continuity of the skin. So if you think of your skin, it's continuous, it's generally smooth, and therefore a wound is a break in the continuity of the skin, as clarified in the case of Moriarty versus Brooks, 1834. And this is where the defendant was a pub landlord who got into an altercation with one of his customers and decided to hit the customer towards the eye, which caused a cut just beneath the eye. And the judge just clarified that a wound is a break in the continuity of the skin leading to blood loss. And there's a phrase that you should always have on the tip of your tongue when you're delivering answers. A wound is a break in the continuity of the skin leading to blood loss, but the blood loss must be external bleeding, not internal bleeding, as highlighted by the case of Eisenhower, 1984. And this is where the defendant shot the victim with an air pellet, which caused a buildup of fluid in the eye, bruising and swelling of the eye as well, but no fluid, no blood actually left the body. So despite the reddening of the eye, that was considered to be internal bleeding, not external bleeding, and therefore it didn't constitute a wound, that particular injury. So a wound, and you should trot this out very quickly whenever you spot a wound, it's a break in the continuity of the skin leading to blood loss, external blood loss, and associate those two cases with that particular statement. Moving on, what does the word inflict mean? Well, we could get bogged down in the technicalities of this, and indeed case law has done that in some respects, but for our purposes, inflict simply means cause, okay? So it obviously speaks of causation. An act which causes a wound, or in GBH, is the same as inflicting GBH or a wound on the victim. So this particular infliction of a wound or GBH, meaning cause, can be caused directly or indirectly, as defined in the case of Hasted 2000. We've met the case of Hasted before in the year 2000, which was where the defendant hit a woman who was holding a baby, and the defendant argued that they didn't commit any offence against the baby because there was no direct physical contact between the defendant and the baby. The judge and indeed the jury did not accept that, and therefore the defendant was found liable of an offence because of the indirect act of hitting the woman, which caused her to drop her baby, and therefore the baby was as much a victim as indeed was the mother. So the act itself causing the wound, or indeed the GBH, can be a direct act, such as a punch or a kick, if you like, or indeed an indirect act, as highlighted by the case of Hasted. Moving on, what does GBH mean? Well, you may have heard me say already that GBH stands for grievous bodily harm, and as defined in the case of Smith, DPP versus Smith, 1961, it means really serious harm, okay? So in the case of DPP versus Smith, 1961, this is where the defendant was driving a car with stolen goods in the back of the vehicle, and the police officer decided to try and stop the car by jumping on the bonnet. The defendant did not stop the vehicle though, and indeed the police officer died from their injuries as a result of that particular scenario. From that case, the judge just clarified that GBH, grievous bodily harm, means really serious harm. Now, that particular case, and indeed that particular charge against the defendant in the case of Smith related to murder and also manslaughter, but for our purposes, we just need to know that GBH, as defined in the case of Smith, means really serious harm, okay? There was a later case, the case of Saunders in 1985, which further clarified that really serious harm means serious harm, okay? So you can use that phrase that GBH means serious harm. Either will do really, but really serious harm or serious harm, it's splitting hairs. There is no difference, if you like, between really serious harm and serious harm. So they're the phrases that you can use for GBH. With respect to GBH, it's important to take the victim as you find them. Now, you're probably familiar with that phrase from causation, and it speaks of the characteristics or the vulnerabilities of the victim. So, for example, you should take into account the age of the victim, or indeed certain features of the victim. For example, do they have any disabilities? And in relation to the age of the victim and whether they have disabilities or not, that often affects the extent of the injuries which they suffer from. So, for example, in the case of Bolland 2004, that was where the victim was a baby who suffered various bruises and abrasions as caused by the defendant, but those bruises and abrasions actually constituted GBH because the victim was a baby. If bruises or abrasions of that nature had happened to an adult, then it perhaps wouldn't have constituted GBH. But because the victim was a baby, the bruises and abrasions was considered to be GBH. And that particular decision was taken by the jury, and it is up to the jury to objectively decide what injuries actually constitute GBH. It's their decision, and obviously they can take into account the actual nature of the victim themselves. You take the victim as you find them, okay? And also in line with that, an accumulation of injuries can constitute also as GBH. Now, in this rather interesting case, the two defendants were both cousins, and the father of Mr. Stratton here, 1997, was actually undergoing a gender reassignment. So that kind of changed from being a man into a woman. Now, Stratton and indeed his cousin, Mr. Brown, was rather embarrassed by this, and that embarrassment was heightened, so it would seem, because their father, or Stratton's father, actually turned up at Stratton's workplace wearing a dress. And as a result of that particular occurrence, both Brown and Stratton decided to go and pay Stratton's father a visit and to beat up Stratton's father. Now, the victim was actually injured insofar as they suffered from a broken nose, they lost teeth, bruising on the face. So it's like an accumulation of facial injuries. On their own, relatively minor, but when taken together, it was considered to be GBH as decided objectively by the jury. So just bear in mind, an accumulation of lots of different injuries on the victim can be considered to be GBH. Also, GBH can also be a recognisable psychiatric injury, as highlighted by the case of Burstow, 1997. And we've met this case before as well when we studied our assault, battery and ABH, because in the case of Burstow, it's where the defendant was the stalker who was delivering silent phone calls, abusive phone calls, hate mail to the victim. And the victim, as it turned out, suffered severe depression because of the actions of the defendant. So that severe depression, and it's important to note that not just mere depression, but severe depression, that constituted a GBH. It has to be, though, a recognisable, diagnosable psychiatric injury, okay? So things like schizophrenia, anxiety, depression, so long as it's on the more severe scale, that can constitute GBH. Also, GBH can constitute a biological transmission of a disease under the case of Decker, 2004. Now, in this particular case, the defendant, who knew that they were HIV positive, actually had unprotected sex with two partners. Now, the defendant did not tell the partners that they were HIV positive, and indeed, therefore, the transmission of the disease, the HIV, was considered to be GBH. And that would include also, I would presume, other serious diseases, for example, hepatitis perhaps, but perhaps not the less serious illnesses that we can suffer from, and indeed which are transmitted from person to person. And it's also important to take note as well that you get into all sorts of problems in relation to causation when it comes to the transmission of a disease. For example, cold or flu, which are kind of like everyday occurrences, everyday transmissions. They happen an awful lot. How do you know who has given you a cold or a flu? It would be very difficult to prove that beyond all reasonable doubt. And indeed, was someone reckless, or did they intend to give it to you? So just be careful when it comes to the transmission of a disease. It would be quite unusual to appear in a scenario, I have to say, but most students remember very successfully what happened in the case of DK in relation to that biological transmission of a disease, and providing it's a serious disease, it can constitute GBH. Broken down all of that, well, the examples of GBH in reality, in scenarios, it often includes serious fractures, so the breaking of major bones in the body, your arm, your leg, your back, humerus, for example, your femur, the longest and biggest bone in your body, they will constitute as GBH. And indeed permanent disfigurement, so serious scarring, if you like, particularly to the face. Permanent disability, a disability that you're not really going to recover from in the long term, or indeed internal bleeding. We know that external bleeding does constitute a wound, internal bleeding does not, because if internal bleeding occurs to the victim and it's serious internal bleeding, that would fall under GBH. And now it's worth clarifying the matter. Well, wounding and GBH, they are separate offences, but can't a wound also be really serious harm? In other words, can't a wound also be GBH? Well, when you get that particular situation, for example, where you get a wound, which could be a stab wound, very serious harm, but it's also a wound at the same time, what do you charge the defendant with? Well, my advice for this is that if you get an injury such as a stab wound on its own, go for the offence of wounding. But if, for example, you get an injury of a stab wound plus various other injuries like broken bones, all of that taken together can be considered to be really serious harm, even though a wound does exist in that particular example. Okay, so if you take all the injuries in the round, loads of different injuries together perhaps, and it constitutes as really serious harm, go for GBH. If you have more exclusively a wound, maybe two wounds, go for wounding. But when a wound is perhaps mixed with other injuries, I tend to go for really serious harm, okay? But where you do get several injuries occurring to the victim, just pause and think, what is the most appropriate charge? Is it exclusively a wound? If it is, go for the charge of wounding. If it's an accumulation of injuries, wound, broken bones, disfigurement, disability, therefore maybe it's more appropriate to wrap that up as a GBH charge. Bit of practice with scenarios should help you deliver the most appropriate charge, but just watch out for that, okay? Worth thinking about what the appropriate charge you're actually going to deliver here towards the defendant. Now, final key word, we get onto the mens rea. It relates to the word maliciously. Maliciously doesn't necessarily mean nastiness or indeed malice or ill will in this particular context. In legal terms, maliciously means an intention or subjective cunning and recklessness to cause some harm. And I'm just dwelling on that, emphasising that phrase, some harm, double underlined, because a lot of students think that when it comes to the mens rea for GBH or wounding, the defendant has to intend or be subjectively reckless to cause the GBH or wound. They do not. They just have to intend or be subjectively reckless to cause the wound. Sorry, I've done it by mistake myself. You can see how easy it is. I'll start again on that particular bit. The defendant just has to intend or be subjectively reckless as to cause some harm, not necessarily to cause the GBH or the wound, okay? So make sure that phrase sinks in. I nearly tripped up on it. Don't let yourself trip up on it. So just remember section 20, GBH and wounding, it's all about intending or being reckless, subjectively reckless, in terms of the defendant causing some harm, as clarified in the case of Savage and indeed Parmenter 1992. In the case of Savage, if you remember from previous videos, that was where the defendant had the pint glass, threw the beer over the victim, but the pint glass slipped out of their hand, causing an injury. In the case of Parmenter as well, we've met this before, that's where the defendant was mishandling a baby and indeed it led to injury of the baby. And in both those cases, it was all about did the defendant actually foresee the risk of the harm which they had caused, which brings us on to the principle that the defendant has to foresee causing some harm, okay? So if they predict that some harm will be caused, then it could be in the remit of a section 20 offence if indeed a wound or really serious harm is the actual result. So remember that they just need to intend or be subjectively reckless to causing some harm. In terms of the terminology, guys, in terms of actually writing down the charge, which can be labelled to the defendant, just state that the defendant can be charged with maliciously wounding, get in that phrase, maliciously, in relation to the wounding, or inflicting grievous bodily harm. So charge them with maliciously wounding or inflicting grievous bodily harm. All that taken together, I hope it was useful. Thanks very much.